The loved ones of Ethiopian asylum seeker Thomas Godiso, who has been detained in terms of the Immigration Act for 7 months now, have filed papers in the Gauteng High Court seeking his release from detention, arguing that he had an intention to apply for asylum, but they were allegedly not assisted at the refugee center.
Immediately when I arrived South Africa, I took him the third day. He has intention already. I took him more than 3 times, and we struggled even transport to take more time. They didn't assist him there. That's why he gave up.
The current climate in South Africa has given rise to a hardened stance to the challenge of illegal migration in the country. During the ANC's 55th National Conference in December, the party adopted the Migration Policy Framework to address the challenge, a prominent feature of the conference. Since then, government has already begun employing strict measures to curb an abuse of the system. Godiso's family, however, contends that his arrival in South Africa and plea for asylum was not abuse.
When we left Ethiopia, we left due to political crisis. There is a war, and we are real refugees. So we didn't abuse the system, and the government must aware that what's currently going on in Ethiopia in the previous 5 years, what's going on, it's not hidden from South African government.
The recent Ashibo judgment delivered by the Constitutional Court found that merely expressing an intention to seek asylum does not entitle one to release from detention. But in Abraham and others, a full court of the Gauteng High Court in Johannesburg ruled the opposite. According to the applicants, this creates a conflict.
The clarity that we are trying to obtain from court is that prior to Ashibo, the Constitutional Court had the principle that upon the expression of intention to apply, then the applicant would be entitled to be released. And then Ashibo is saying the opposite of that. And then we are saying that we should not move away from settled law or settled principle.
In papers before the High Court, the National Prosecuting Authority argues, among other things, that the applicants seek to bypass administrative remedies provided for in the Refugees Act and instead seek immediate relief from the courts, which the NPA argues is premature. And on that basis alone, the application should be dismissed. The matter is expected to be heard before a full bench on 13 November 2023. Kani Mapanga, SABC News, Springs.